Welcome to a free on-demand webinar presented by Michigan Alliance for Families. We partner with experts from across the state to offer live webinars to help answer the questions we encounter most frequently. Our webinars are recorded and saved for future viewing. Handouts for our webinars can be requested through our webpage, michiganallianceforfamilies.org/webinar. Remember to keep up with Michigan Alliance for Families on social media, and be sure to check out the other videos on our YouTube channel. Follow-up questions to this webinar can be directed to us at info@michiganallianceforfamilies.org. Today's webinar is Early On, Prior Written Notice with Stacy Rulison. Welcome, Stacy.
Hello, and thank you for joining us today. You've selected a webinar in a series of webinars related to Early On. Early On is Michigan's early intervention program for helping families whose infants and toddlers have developmental delays or are at risk for delays due to certain health conditions. Early On is Michigan's early intervention program covered by the federal law, the Individuals with Disabilities Education Act, or IDEA. This is Part C of this federal law. Today we'll be covering prior written notice. This is webinar 4 of 4 webinars on your rights related to procedural safeguards. In this webinar, we will specifically discuss prior written notice. This relates to laws that protect you and your child. We hope to help you understand more about this important information. Additional webinars will cover the other topics related to procedural safeguards, including records and confidentiality and parental consent. There are a number of objectives in sharing information from this webinar we will talk about today. This includes participants being informed about the meaning of prior written notice, being informed about requirements of prior written notice to parents from the program, being informed of what is included in prior written notice from the program, and being informed of parent actions if prior written notice is not given by the program. There are also resources that can help families better understand prior written notice. The Michigan Alliance for Families website is provided on the link on the screen. And on this page, you can access Early On Procedural Safeguards Protecting Families' Rights, access your Family Has Rights brochure on the page, and there are many other resources related to procedural safeguards, including prior written notice on this page. The first thing we'll talk about is defining prior written notice. It has to do with being a legal requirement under the Individuals with Disabilities Education Act. It is written information given to parents to inform them ahead of time about a proposed action or change, requiring Early On to explain any changes being considered to the child's individualized family service program. When considering prior written notice, there are certain requirements. You must be informed with an explanation and reasons why an action is being proposed or refused. Procedural safeguards, including anything related to mediation, how to file a state complaint, and due process, and timelines related to each of the procedural safeguards is included. The prior written notice must have enough information to inform parents. You must be informed with a description of action of the program they will not take, an explanation of why the program will not take action, a description of each evaluation procedure, assessment record, or report the program used for deciding whether to suggest or refuse an action, a description of choices the individualized family service plan team considered and reasons they were not selected, description of reasons why programs suggested or refuse an action, and what parents can do if they don't agree. Here are some examples of when prior written notice would be needed, would include the following. The program wants to change early intervention placement from a disability-specific from the home to another setting. The program wants to change any of the early intervention services your child is receiving, such as a decrease in the amount of time speech services are provided. The individualized family service plan team determined a request for a change in service was not necessary. So these are just some examples of when prior written notice would be required. If the program does not provide prior written notice to you, or you are not informed of changes they are proposing to your child's programming, the following actions can be taken, including you can send a letter to the program indicating you do not agree with what the program is suggesting, or you do not get prior written notice. You can request mediation or a due process hearing. You can reach out to a parent mentor with Michigan Alliance for Families, or you can contact the Special Education Mediation Services, sometimes called SEMS, free of charge to discuss your concern and look at different options for resolving your concern. There are additional resources that may be helpful in considering prior written notice requirements. Some of the resources are listed below on the Early On website. They can be found at the Early On Michigan Family Guidebook, Procedural Safeguards Protecting Families' Rights, List of Established Conditions, Request for State Complaint Investigation Forms, Early Intervention, Early On Due Process Complaint Procedures, Prior Written Notice, Early On Parental Consent, Authorization to Release Early On Records, Early On Parental Consent for Developmental Screening, and more.
Thank you, Stacy. Michigan Alliance for Families is an IDEA grant-funded initiative of Michigan Department of Education, Office of Special Education, and we're Michigan's federally funded parent training and information center funded by the U.S. Department of Education, Office of Special Education Programs. Follow-up questions to this webinar can be directed to us at info@michiganallianceforfamilies.org or call our 800 number, 1-800-552-4821. Thank you.